Good afternoon, everybody. Thank you for joining us today for our webinar about everything to do with hiring in Germany. We've got, again, a lot of people registered and a lot of people attending. I can see them pouring into the session. So we're just going to wait a few seconds as people join, and then we'll get started. Whilst we're waiting, if you guys do have any questions that you want to pose to our expert today, Thomas and I, then please do put them into the Q&A, and we'll be able to get those questions in at the back end of the session. I'm aiming to leave sort of 15 minutes towards the end where we can answer some of those questions. So we'll wait for another minute or so because we've still got people joining thick and fast, and then we'll get started. Okay, so I think the numbers are starting to slow down a little bit, so we'll make a start. Good afternoon, everybody. Thank you very much for taking the time to join this webinar today, brought to you by Giant Group, and it's entitled Everything to Know About Hiring in Germany. So the clue's in the title, guys. We're going to focus today on some of the key considerations from a compliance and legal perspective when businesses are looking at engaging and hiring workers in Germany. So we've got about 45 minutes in the session where we'll discuss a number of different topics. We've got people joining interestingly from all over Europe today, which is great. So please feel free to introduce yourselves in the chat function. If you'd like to say where you are today, then please don't be strangers. But I think in general, it doesn't matter whether you're an end hirer or a recruitment business or MSP who look to help clients find talent. The reality is we're all operating in countries where there's just a shortage of talent across the board, and in particular in major industry sectors. We can certainly see the increasing use of contingent workers to plug those talent shortages, not least Germany. I think Germany's popped up in several conversations that I've been having over recent weeks, and it's a large marketplace with lots of talent there, and it's interesting to see companies in the UK and abroad looking at trying to tap into that resource. So in terms of the topics that we want to cover off today, we'll start by looking at the terminology that's used in Germany when we're talking about temporary workforces. I think we all have our own phraseology and terminology in different countries. So I think it's always nice to sort of get that synced so we understand the differences in terminology, and that should set the scene for the session. We'll then do a deep dive in that thorny old issue of worker misclassification, which obviously is a theme that we're all familiar with, and Thomas will walk us through the specifics around how that operates in Germany. There's some interesting examples as well, which I won't spoil on, but I think there's some interesting behaviours coming from some of the German organisations around that, and we'll let Thomas use that analogy to bring things to life. We'll then look at the different ways that you can look to engage contractors and the sort of solutions that are available in the market. For our recruitment agencies and hirers that are on the call today, we'll also take a look at the specific requirements that are needed for recruitment businesses to be able to operate in Germany. We'll take a little bit of a look at MSP models, which are quite advanced in the UK, but not necessarily in Europe, and Thomas will share his thoughts on that. And we'll finish off with any other topics from a legislative perspective, and of course your questions. So please do make sure that you submit those on the Q&A function as we go through the session, and I'll make sure we've got plenty of time to address those at the end. So today's webinar is brought to you by Giant Group, a leading contingent workforce management business for 30 years, and also Klimt Lawyers, one of Germany's leading specialist firms for employment law. I'm delighted to be joined today by Thomas. Good afternoon, Thomas. How are you?
Hi, Dan. Thank you. I'm fine.
Good. It'd be great if you want to introduce yourself to the audience, and then we can start to get stuck into topics. You've got a lot of work to do today. We've got quite a lot to get through.
Definitely, yeah. Thomas Leister, partner at Klimt HR Lawyers. Some of you might know me from my previous firm. I've I was partner at Osborne Clark for more than 16 years and now joined Cleaned HR Lawyers as of 1st March 2025. So thank you for joining, and I look forward to speaking with you.
Good. Okay, so I think let's begin then, and let's first start looking at the terminology that we use when we're discussing contingent workforce. There are often lots of acronyms and phrases that we use in this market. So it'd be great, Thomas, if you can just sort of explain the scenarios and the wording that you use over in Germany, and I'll try and add some context from a UK perspective as well.
Yep, perfect. Thanks, Dan. So it's always good to have a clear understanding of what we are talking about, and there might be some differences. So some thoughts about terminology. When we talk about temporary agency workers in Germany, we mean AÜG workers, in Germany Zeitarbeitnehmer. So those are employed workers working for a company that has an AÜG license, and the worker has a formal employment contract with the agency, but actually works for the client. In contrast to AÜG workers, we have self-employed workers. We call them independent contractors, freelancers. The main differentiation is they are independent. We will come to this point later. Then we have the wording sole trader, freelancer. It's a so-called solo Selbstständiger that can be, so in general, it's an independent contractor, can be a person on its own or a person running an own company. And then we come to the limited company. In Germany, it's in general the GmbH. Can be run by several people. Sometimes it's used by sole traders so that they can market their business as a GmbH. And sometimes we have to deal with consultancies. Consultancy is in German language Beratung, and consultancy can be done via service contracts, via statement of works. So it's just a wording for the type of organization. The main legal differentiation is dependent employment relationship and independent contractor relationship.
Yeah, okay. So I think from a consultancy perspective, that all sounded familiar. Statement of work, consultancy, work packages, that makes sense. And again, there's some alignment there in terms of the worker types that you've been through. You can have a temporary worker, an AÜG license you've mentioned. We'll come back round to that later. Or you've got independent contractors who could be a person on their own, i.e. a sole trader, or they may make the decision to use their own limited company, which we call a PSC, personal service company over in the UK. So I think from a worker type perspective, from what you've been through, Thomas, that seems to be reflective of the sort of engagements that we have in the UK as well.
Yes.
I think what certainly will be interesting here and taking a big deep dive, it seems to be the conversation, no matter which country you're in, the hottest topic in all areas, and it's around this thorny old issue of worker misclassification from a tax and an employment perspective. You know, what are the rules that are used to decide how someone should be engaged and how potentially their tax should be paid. So it would be super enlightening, I suppose, to hear from you on how those rules operate in Germany. We, of course, in the UK have been kicking around IR35 now for a number of years, and it's been an interesting journey. But it would be great to hear from you how that operates over in Germany and what are some of the considerations that the audience should be aware of.
Mm-hmm. Yep. So the basic principles regarding the differentiation between dependent employees and independent contractors are relatively similar in the US, in the UK, and in Germany. That means if you're familiar with the UK system or the US system, you will see some similar points here in Germany, but there are differences in detail. In contrast to employees, freelancers, independent contractors are not personally dependent in their work. An employee is any person working for another person in personal dependence based on a contract subject to private law. You see, that's a very abstract definition, and we have to fill it with more details. The crucial criteria for an employment relationship are the personal dependence on directives regarding place, time, and specifics of the work performed, as well as the integration into the operating organization of the person issuing the directives. The following points in particular indicate a personal dependency and therefore speak for an employment relationship. And this is just some examples, the most relevant points. It's not a comprehensive list. First point, dependence on directives regarding the place of work. Dependence on directives regarding working time, in particular regarding the beginning of the working time, when breaks can be taken, and the end of the working time. Integration into the operation of the principle. No entrepreneurial behavior at the market. No financial risk. If you have one of those criteria met, then the risk that this person is not an independent contractor, but a dependent employee is relatively high. It's important to know that for the delimitation of employee and independent contractor, the actual implementation of the contractual relationship is crucial. The term of the contract and the desired legal consequences are not the decisive factors, but the content and its practical execution. If the contract made by the parties and the practical execution conflict with each other, then the practical execution of the contractual relationship prevails in any case. That means it does not really help if you have very nice contracts if you can't execute them in practice. So you need to check at the beginning, can this type of work be done by an independent contractor? And if yes, then you should think about the proper contracts and the proper implementation in practice. Thanks, Dan.
Yeah, no, that makes sense. And I think you're reiterating the point that we should all be familiar with, that you as a great lawyer can make a contract say anything, right? But it has to be backed up by the working practices and what's actually happening on the ground. Is the spirit of the contract the reality of the situation, and those two things need to marry up for it to be an authentic arrangement. Yes,
exactly. Yes.
Yeah, okay. I think it would be potentially then quite interesting for you perhaps to sort of bring that to life with some real life examples that you've been reviewing over in Germany. It'd be fascinating to hear a little bit more about how that sort of relates to real life examples, Thomas.
Mm-hmm. So, as you heard, the starting points for the delimitation of an employee and an independent contractor are relatively vague. It's very abstract, and it's, even if you ask specialized persons, it can be difficult to get a clear answer. And in addition to that, the authorities and the courts in Germany decide on the status of the worker on the basis of all points of the individual case. That means if you try to prepare a lot of arguments for an independent contractor relationship, it could be that an authority or a court says, yeah, but we found arguments for a dependent employment relationship, and at the end, after an overall assessment, we think that the arguments for an employment relationship prevail. So what we have seen in practice in a lot of status decisions is if the freelancer is paid on time and material basis, authorities and courts like to argue that this is similar to the payment of an employee. Yeah, the employee is paid for a certain working time, 40 hours a week. And if you then have an independent contractor preparing invoices on the time that he or she spent on the project, then they can say, oh, we know this from an employment relationship. And that's what often happens. If something is possible in an employment relationship or is done in an employment relationship, they like to argue, oh, this is an argument for an employment relationship. So what we've seen in the last month, it was communicated in the industry that the German pension insurance, that's the relevant authority when it comes to status determination, that this German pension insurance engaged freelancers for their artificial intelligence support. They would like to introduce artificial intelligence to strengthen their audits. However, they do not have the people that can do this, so they needed independent contractors. And it came up that the assignment periods were relatively long, so up to 3-4 years, that the independent contractors were paid on time and material basis, that some equipment was given to the independent contractors. The German pension insurance was contacted, and people said, okay, can you clarify this? Because in general, you argue that it's a dependent employment relationship if you use those points. And the German pension insurance said, this is the individual decision in this specific case, and we have to assess all the topics in the individual case and then make a decision. So in this case, the German pension insurance thought that it was a true independent contractor relationship. Let's see whether it will help us when arguing in other cases and the same points are given.
Yeah. I detect a whiff of irony in the air here, potentially, Thomas. That the body that's responsible for managing that has got these freelancers in, and on a case by case basis, all those factors obviously need to be reviewed. But we've seen in the UK that there's been a lot of battle lines drawn under this, and often it's the public bodies that seem to get this wrong, and then it does lead to a frustration for the private sector, who are of course trying to make sure that they can apply by the rules. It's probably worth mentioning as well at this point, it's quite a high bar, right, in terms of the risk of getting this misclassification wrong in Germany. What is it? It's a criminal risk, is it, potentially, if you get this wrong?
Yes, it can be a criminal offense. If you do not deduct the employee's part of Social Security contributions, this can be a criminal offense.
Yeah. Okay. So that's certainly, that is a very high bar. It's higher than in the UK. So you can understand why businesses are cautious then on this point. But equally, commercially, we understand there's a lot more cost involved potentially when you're engaging someone as a worker, as an AUG worker, or someone who's employed, because there's obviously all the employment costs that need to bear. So you have this constant tension between what's the commercially most cost-effective way to engage with the least risk, but also bearing in mind, if you get this wrong, then it's quite a high bar. So it'd be fascinating to hear how that case pans out, and maybe we can have an update session later on in the year to hear about that. So I think there's obviously different ways that companies can obviously look at how they might be able to manage and reduce the risks in this area. So it'd be good for you if you could sort of bring to life some practical tips and suggestions as to how the audience can think about trying to avoid a misclassification problem, given that the risk is high in Germany.
Yep. So the starting point is the question, can this work be done by an independent contractor? If it's possible, then you should use as a starting point proper contracts. Care should be taken to ensure that the content of the contracts for independent contractors is designed in such a way that the contract clearly implies a freelancer relationship. So what we do not want to see in an independent contractor contract is something like employer-employee, directives, monitoring, reviewing, supporting, assisting, helping, everything that can lead to a dependent employment relationship should be avoided. Then the second step is the practical implementation. Yeah, as already mentioned, you can spend a lot of money for getting proper contracts. If you can't execute them in practice, then they are not worth the money. So if you have the right contracts for this situation, you need to ensure that the practical implementation of this independent contract relationship can be clearly and exclusively classified as an independent contractor activity. And some points that should be taken into account in particular are as follows. The contractor should ideally employ an employee. We see that this is not the standard case in practice, but it will definitely help for several reasons. One reason is if the contractor engages an employee, the contractor has a financial risk because he has to pay the employee, whether there is work or not. And having an entrepreneurial risk is a good indication for an independent contractor. And the second argument is an employee does not engage another employee to perform the work in the employment relationship. So it's a clear indication that the person engages an employee and is therefore able to engage one. So it's not relevant whether the independent contractor provides the work on his own. He can use other employees. Then it might be good that the contractor also works for other clients and advertises on the market. We see a lot of contractors working for just one client, and this can be okay, and it's not a clear indication if a person has several clients that this is an independent contractor, because courts say we have seen a flexibility in the employment relationships, and a lot of employees have not just one employment relationship, but 2 or 3. The next point is the contractor should use his or her own work equipment to carry out the work. The contractor should have his or her own email address, business cards, phone numbers that have no connection to the client. And if there is a connection, then it should be clearly mentioned, for example, in the email address, Max Miller at external dot and then the company. The freelancer should work in his or her own facilities. Yeah, ideally the freelancer rents a small office. That would be helpful. And then, of course, one of the most relevant points, the contractor should carry out the work free of directives with regard to the content, performance, time, and place of the activity. These are just some examples that can definitely help, but it's not an exhaustive list. What you can also do to reduce the risk of worker misclassification is implementation of a contingent workforce compliance system. That can definitely help. Even if there is a case, you can show to the authorities and the courts that you take care of this. and this will definitely help when it comes to personal liability or criminal liability. German law has an option to ask the German pension insurance to decide on the status of the worker. Yeah, it's called status determination procedure or inquiry proceeding, Statusfeststellungsverfahren in German language. It's not used that often because you ask the company or the authority that is responsible for getting all the social security contributions, and if you contact them, it could be that they have a deeper look. Is this just the only relevant status, or were there any other freelancers maybe misclassified in the past? It takes some time, so I would be careful. It can be a very good option, but you should be careful.
Yeah,
Thanks, Dan.
yeah, that made sense. I suppose it's you're a brave person, flags to the authorities. You're looking at engaging somebody unless you've got your sort of all your factors in play. And it also doesn't sound like that would be a particularly quick process. So when you're dealing with a volume of workers, then perhaps not too practical. Obviously, we've wrestled with the ability in the UK to the authorities have an online tool to do a job. Again, some people think it's good, some not, but at least there you can process volume through it. And perhaps that's the direction of travel in Germany and that AI project to try and help speed decisions up. But ultimately, it sounds as though you need to rely on your own evidence and your own keeping records, basically. So if you are asked, you've got something to back up how you arrived at that decision, Thomas, which I think makes sense. And all the factors that you were running through there in terms of control and working for different clients, I think would again be themes that we're also familiar with in the UK when you're looking at status. I think it's interesting in terms of looking at different ways that people can look at operating and engage in contractors. There's certainly businesses out there now that can provide services to manage that, Giant being one of them, but there are others. I mean, if you go back a number of years, self-employed was the main way for contractors to be engaged across Europe, but we've moved into an environment now where all countries are looking at trying to increase tax take and sort of drilling into the detail here on these engagements. Doesn't matter whether it's in Germany or Netherlands, which interestingly we're doing a webinar next week on the Netherlands if any of the audience are also interested in that. So super important that you're going through a process, you're keeping a record of how you've come to that decision, and if in doubt you probably want to be leaning on the side of engaging someone as an employee if you don't want to fall foul of the tax authorities. So let's now move on then to look at different ways in which a worker could be engaged and the sort of suppliers who may be able to help provide those workers. It's probably useful at this stage to outline to the audience the sort of types of providers and solutions that are in the market that provide employment solutions, often referred to as EOR services, and also help businesses engage freelancers, sole traders, or contractors using their own limited company, sometimes referred to as AOR or agent of record services. And certainly our Giant Global businesses is used to providing those options for a variety of different countries around the globe. An EOR service is effectively an employed solution. So that's when the worker will have an employment contract with the EOR service provider. That could be open-ended or it could be a fixed term. But each month there's going to be a payroll run. The worker would receive their net pay along with a pay slip, and all the taxes will be deducted at source by the employer. The employment costs and associated tax will be paid to the local authorities. And effectively, those providers provide an option to companies who can effectively use those EOR services to take on board the worker. They just simply have to make a payment to that provider, and the provider deals with the technicalities of making those tax payments. In respect of AOR, agents of record, that's where the worker's probably operating as a self-employed person. So that could be as a sole trader or often contractors use limited companies to operate in that way. And then with that solution, the AOR provider will receive a payment from the hirer or the recruitment business that wishes to use them. They'll often then do a worker classification check, so look at some of those factors and variables that Thomas mentioned there to assess whether this worker is appropriate to be engaged on a self-employed contractor basis, and then effectively make sure that the taxes are paid as part of that, or simply make a gross payment to the worker if they are comfortable that the worker can operate in that way. So you can see a rise, I think, of those sorts of providers in the market. And as I said right at the beginning, everyone's searching much wider now and looking globally for talent. So these employer of record services are becoming more and more popular. So it's just important that you make sure you do your due diligence when you're selecting those providers. Make sure they're reputable. They've got good, strong advisor links and networks to advise on status. But it'd be great, Thomas, I suppose, you'll come across these businesses as well as us. So it'd be good to get your views on those different ways that workers can be engaged and the sort of suppliers and providers and your views on them.
So the most common engagement types in Germany are independent contractors, individual person or own limited company. The pros for using contractors: you have access to specialized skills, it's flexible, no need to provide benefits, pensions, or the employment laws. The cons: less control over contractors, risks related to confidentiality and intellectual property, high organizational and legal effort regarding compliance, to reduce or the risk of worker misclassification. Then AUG workers, agency workers, those are employees engaged by the agency and then assigned to the client. The pros: you have workforce flexibility. You do not need to engage them directly. You can lend them from the agency. It's a reduced administrative burden as the agency handles payroll, etc. The cons: it costs. You have to pay the agency fees. AUG is highly regulated in Germany, and at the moment, so since the last changes to the AUG in 2017, we've seen a stronger regulation, in particular regarding assignment limits. So in general, up to 18 months, and then principles of equal pay and equal treatment. As Dan already mentioned, EOR, employer of record.
Thomas, sorry to interrupt you, but just before you move on from that, I think we've heard AUG mentioned a number of times, and I know we always get asked first, particularly from the UK-based recruitment businesses who are interested in setting up over in Germany, like what are the requirements? So just in terms of that AUG license, is it easy to get hold of? What are the costs associated? It'd be good just a little bit of detail in that area, if that's okay.
Yeah, definitely. So the most important thing is you need to have a license to do employee leasing under German law. And to get this license, you need to collect a lot of documents. You need to prepare templates for an employment contract with an AUG worker, a template agreement between your agency and a client. Okay. What we've seen in practice is that it can be difficult to collect all the relevant documents. In particular, if you have to provide the documents from several countries. And we sometimes face the situation that even the employment agency, as the relevant authority, does not know what they would like to see. And then we try to discuss with them, this is what you would like to see in a standard case. Since this is not a standard case, we think that this could be a good solution. Please confirm. So sometimes it can be difficult to meet all the requirements, and at the end the authority will decide when all requirements are met, and that means it can take some time. Okay. So if it's straightforward, it can be within 1 to 3 months. It can be longer, 6, 7, 8 months, depending on the speed.
Yeah? Okay. So it needs some planning then. If people are going to look at entering the market, they just need to ensure that they've got a nice runway, basically, of a number of months, bearing in mind the length of time the process will take. Now, I think that was really useful, and sorry for interrupting you. I think you were just about to move on to talk about employer of record and your views on those companies.
Yeah. So employer of record is a proper business model in the relevant local countries. There are differences in detail. In some, it's not possible. In most countries, it's possible, but you have to check the local requirements, and that can be relevant. So it's not possible to say comes from the US and it works in the US, and if we use our standard US model all over the world, that will work. That will be difficult. Consultancies can be service contracts, statement of works, whatever. What we see in practice is that it's very relevant to have a proper service description. So which services shall be provided, and this is in particular relevant for statement of works. So these are the main types of engagement: independent contractors, AUG workers, EOR, consultancies.
Cool. Okay, good. So thank you for everyone who submitted questions so far. Just a quick reminder, feel free to hit your questions into the Q&A. Thomas and I will try and cover as many of those as we can in the session. If we miss any, we're happy to provide the answers on a follow-up. And I will come to one of those questions actually once we just move through the next topics. I think it's relevant to this next part of the session, which is going to be around MSPs. So we're familiar with the MSP, managed service provider recruitment models in the UK, Thomas, but I'd be really interested to hear a little bit more about MSP providers and how that runs in the German market. I know you've got particular experience of looking at this and some views, so it'd be great to share those with the audience, and then I'll pull out a question that we've had at that point to address.
Fine, yes. So the good news, MSP arrangements are legally permissible in Germany, provided they comply with the relevant labor laws and regulations. In the traditional MSP structure, the MSP agrees and signs the contracts with the suppliers. And this is where the German system can be different. If AEG workers will be used or can be used in an MSP program, then we have an issue under German law, because German law prohibits chain leasing. That means there must be a direct contractual relationship between the end client and the supplier. So the MSP must not be part of the supply chain. Yeah, there needs to be a direct relationship between the supplier and the end client. Now the solution is the MSP agrees and signs the contracts on behalf of the end client or the suppliers. Then there is a direct contractual relationship between the end client and the supplier. From a legal point of view, it's a fundamental difference, but not from a practical point of view, because the MSP signs, agrees the contracts, but not on his own, on behalf of a third party. Yeah, and that's important. Otherwise, the whole structure will not work. But at the end, yeah, from a practical point of view, it's not the signature of the MSP on its own. It's on behalf of the client.
Yeah, that makes sense. And it's interesting. We had a couple of comments just coming on the chat where people are not familiar with the terminology of MSP. So I'll just very quickly help on that. What we're talking about here, guys, is where a large organization often will use a business to manage the recruitment process across a number of different recruitment agencies. So you normally have the client here, a managed service provider in the middle, and then in the UK we have lots and lots of recruitment agencies, and perhaps that MSP might be doing some recruitment themselves. But the MSP party, that company, is effectively managing the supply chain. And they're usually directly in the contract chain. And what Thomas was just saying there is, from a German perspective, the MSP can still operate and manage on behalf of the client, but there has to be some consideration to that contractual chain, Thomas. Yeah, make sure that the hirer has a direct contractual relationship with the recruitment business that can be managed operationally by the MSP, but you've got to be very clear that the chain is correct. And that's slightly different than the traditional model, which is a little bit like a pyramid. Yeah, client at the top, MSP underneath, and then everything downstream. Would that be a fair summary?
Yep, definitely.
Yeah. Cool, good. So hopefully that was helpful to those that were just popping that in the chat. Is there anything else that you wanted to raise there on MSP before we just go and take that question that I spotted in the chat, Thomas?
Fine from my side.
You're good. Okay, let's go. So Clive, nice to see you, and thank you for joining the session. You'd asked a question which I'm just going to scroll and dig out because you'd asked it early on. So here's one for you, Thomas. What approach do you suggest for starting discussions with German works councils on implementing a full MSP and VMS service? That's from Clive Mills, who runs the contingent workforce at Warner Brothers.
Yeah, very good question. And the starting point is, please explain to the Works Council what an MSP is, what a VMS is. Most of them do not have any idea of what you're talking about. And if someone is not familiar with it, they are reluctant. Oh, no, we do not want to have this. We do not know what is coming. So the first thing is just explain it to them. Yeah. And if they then understand what an MSP is, what the benefits of an MSP are, then it will make your life much easier. I've seen this in discussions with works councils. If they are not familiar with the model, then you can't negotiate about implementing such a model. So information.
Yeah, very good. No, it was great. It was a good question, and I thought it was just a nice one to drop in there as we went through that topic. I promise I'll not go off piste anymore now, Thomas. I know you like your skiing, but I'll make sure I stick to our agreed format. We're coming to the end of the session now, and we're just down to our final topic, which was just for you to give us a bit of a heads up if there's any horizon scanning to be done here on legislation that could be coming down in the future that you want to put on the audience's radar. And then once we've done that, I think we'll then move in to finish off with the rest of the Q&A that we've got left.
Mm-hmm. Yeah, fine. So one thing that will be very important is the EU Platform Workers Directive. It has to be implemented in the local countries by the end of 2026. So the directive aims to prevent platform workers from ending up in worker misclassification, and therefore there shall be a legal presumption of employment at a local national level. Therefore, the platform provider needs to prove that this person is an independent contractor. How this shall be in practice, that's part of the local legislation, but the general principle is clear. The status of platform workers shall be strengthened, and it can be more difficult in the future to argue that such persons are independent contractors. Let's see what will happen. And please do not think our platform, we know the typical platforms. Platform is relatively wide. Yeah, so we have to check in each country what they understand under platform worker. So that will be an upcoming topic that you should keep in mind. Another, but it's more a hot topic regarding MSP is whether the MSP can collect all the invoices from the supplier, deduct the MSP fees, and then pay out everything. If the MSP is in the payment chain, then it's a question, and it's still disputed whether a specific license is required. Under German law, the license would be granted by the BaFin. Very few companies have such a license. Others say we do not think that we need them, and other MSP providers are just out of the payment chain, so that there is no risk. But that's an ongoing hot topic. The more relevant one is the Platform Workers Directive.
Yeah, no, but I think both are super interesting, and it comes to your point around that you made earlier when you were talking about employer of record, that not every solution is the same. You can't just take the badge at the top and say, okay, it's X. You actually need to get underneath the bonnet and have a look at the detail, because everyone has slightly different operating models, and you need to understand that. I think your observations on the platforms is very relevant. I saw a crazy stat couple of weeks ago that said, I think there's an anticipation that something like 40 million people will be engaged by a recruitment platform by the end of this decade. Like, the numbers of people that are working through these platforms is huge. So you can understand why the EU are looking at trying to tackle that from a misclassification perspective. Is it, then there's a question for you, where does the risk sit on that directive then? Is it the platform that could effectively pick up the tax burden should they not be treating the contractors the right way, or does that risk fall elsewhere in the supply chain?
It can also hit the end clients, but what we see in practice is that the providers often have to take the risk. And the Platform Worker Directive is, if you read it, it's more the stronger focus on the platform providers. Yeah.
Okay. No, that's useful to understand, because I think, again, this comes back to supply chain, doesn't it? And organisations at the top, the higher, are being aware of actually what is happening in their supply chains, and understanding that if that's not being appropriately managed by those suppliers, there could be some risk that moves further up. And again, you see that with MSP arrangements, as well as with platforms who can often use other providers to support with services underneath. And before you know it, you think you're engaging one organisation to deliver something, but actually there's 2, 3 or 4 different providers in the chain. So important that if for end hirers that are on the call, that they've got some visibility to that. Thomas, I think that comes to the end of the session. That was super useful. Thanks very much for your insight and us going into those topics. I can see from the Q&A coming through that the audience has certainly been engaged on it. Maybe now, just for the last sort of 10 minutes, we'll have a pick through some of these questions. And like I said, if we can't get to all of them, we'll be happy to follow up with answers. So let me scroll down, because we've got a long list. You'll be pleased to know, or not. Let's just have a look here. So get to the bottom. So first question I would pull out would be from Joe. Do employers in Germany only want EU residents or EU citizens? That's quite a broad question. I'd anticipate maybe the answer to that is not necessarily, but in your experience, do you see German clients only wanting to hire people from the EU, or will they happily consider people from outside the EU?
From all over the world.
Yeah.
we are no longer in the situation that we can say we focus on Germany or on the EU. We have such a lack of skilled people from all over the world.
Doors are open for business in Germany. We're hearing that loud and clear. Second question: are there still requirements for all non-EU citizens to obtain a valid work permit well before they even travel to Germany? So does that non-EU individual need a work permit before they travel? What's your advice there?
It depends on the specific country. There are countries where it's easier. They can come to Germany and then apply in Germany for a work permit. Others need to have it before they enter Germany. So it depends on the individual person and the country coming from.
Okay, good. Question from Emma. Hi, Emma. Good to see you on another one of these webinars. In the event of misclassification, who is liable, the agency or the end client? So we've jumped to the misclassification topic and specifically liability. If an agency is being used by an end hirer, where does that liability sit?
Yeah, it could be both. Yeah, everyone in the supply chain could be affected. If the end client integrates the contractor into its organization, issues directives, monitors the work, and so on, then from a legal point of view, it's relatively clear that the end client is the employer. However, sometimes there is a different situation in practice that the agency is liable.
Okay. So a good reminder, each circumstance is different. If you're a bit unsure, take some legal advice on that particular scenario. Next question: is there a maximum assignment period for an agency worker, such as RPOs and not least labour? So, with regards to German law, is there a particular maximum assignment length for an AUG worker?
For an AUG worker, the general maximum assignment length is 18 months. That can be longer, in particular if it's agreed in collective bargaining agreements, but the general rule is 18 months.
Yeah, okay, good. That's a simple answer to that question. Thank you. Tatiana has a question for Thomas. Thomas, if a company would like to expand in Germany, would you recommend setting up a legal entity directly rather than going with an EOR company first, given the 18-month limit?
It depends on the specific case. Yeah, sometimes it absolutely makes sense to use an EOR provider. If you are convinced that you would like to do business in Germany, you can start with a GmbH, engage employees. Both options are possible. It depends on your plans. The good thing is you have flexibility.
Yeah, I think another point to add in there as well, Tatiana, is it actually depends on the nature of the people as well and what their roles are. So if you have people who are revenue generating or in particular senior offices within a company like an MD, then it almost becomes the need to set up an entity in the country anyway for those purposes, rather than being able to outsource to an employer of record. So that alongside your own strategy, how many people you're looking to place, what's the long-term strategy, will probably influence EOR versus your own entity. We often see clients using our EOR systems and services for an initial period, and then they pivot to set their own entity. So you can also kind of use a hybrid of the two as well. Thank you. Question from Rona. It's a long one. So we have a small number of people in Germany, business development people with German contracts employed by us in the UK. We have others in the UK team who travel to Germany to support them at exhibitions or with customers as required. Are there any additional requirements for our UK people traveling to Germany to do this, other than limiting them to the number of travel days permitted? So they've got some salespeople over in Germany selling for them on behalf of the UK. Some of the UK team travel across to support them from time to time. Are there any additional requirements apart from making sure they limit the number of travel days permitted?
Yeah, they need the A1 certificate if they come from the UK to Germany for business purposes. that's, I assume that is already in place. But that would be the first thing that I'm thinking of.
Yeah.
And what we usually see is if it's just people supporting the German team, okay, but sometimes it's not just salespeople supporting people in Germany, but that, for example, the managing director is not working in Germany, but outside of Germany, and that could then trigger tax issues.
Yeah, and I suppose just as well for context, that A1 form is effectively where that individual is registering to pay social security in that country, right? Yeah. And again, you'll see that often where contractors will register, and then between most European countries, there's double taxation treaties. So tax paid locally in one country can be offset against the UK tax bill. So people aren't having to pay two lots of social security where those treaties are in place. We're getting taken on a winding road of different questions and topics here, Thomas. So let's look at the next one. Question from Nisha: can a contractor use his or her own limited company in an MSP arrangement? So I think the answer to that would be yes, right? So if a contractor wants to be engaged as a limited company, there's no reason why they can't do that within an MSP model.
Yes.
It would
From a legal point of view, it's fine.
Yeah.
Yep.
Yeah. You'd just be interested in making sure the who is engaging that contractor. Is it the agency, and what does that contractual arrangement look like between the agency and the end hirer, to your earlier point on chain law? Yeah.
Yeah, and in general, it's the question: is this a GmbH where there is only one natural person behind it? Then we have the same risk of worker misclassification.
Yeah.
Yeah, but that does not belong to the MSP.
No. Okay. Very good. Question from Michael. I'm not sure if it's too far off topic, but how challenging is it to reduce the workforce if projects are lost? And I think that's a very good question, Michael. We're talking about temporary workers here. And of course, one of the reasons that businesses want to engage temporary workforce is because projects ebb and flow. So in that respect, if someone had a large temporary workforce and needed to reduce it, how challenging is that in Germany, Thomas, in your view?
Yeah, if you are the end client and you have AEG workers, yeah, you can end the assignment. Yeah, you have to check what is agreed in the employee leasing agreement, but that's it. Yeah, you do not need to take care of any dismissal protection rights. That's the responsibility of the agency. Yeah.
Yeah.
So it's relatively flexible to use AEG workers, in particular if it comes to project is over, what to do with the workers.
Understood. Okay, we've probably got time for maybe one or two more, and then we'll review the remainder and see if we can do some follow-up. In terms of setting up a GmbH company, is there a portal or a website where you need to do that within Germany, or are the companies that provide those services? How easy is it to set up a GmbH business in Germany?
You need to prepare some documents. You need to go to a notary. Then the documents need to be presented to the register court. So that it's not in a portal. You have to do some work. You usually need some support. Yes.
Okay, so it's not just a simple online process. You need some paper and wet signatures. Yeah.
Oh, that's, for example, if you register with the trade and commercial office that you're doing a business, that's online possible, but not the registration of a GmbH.
Okay. I'm going to pick this last one up and stretch myself out of my comfort zone because there's some German language here, so don't shoot me now for my terrible pronunciation. Last question from Kylie. Do we need to set up a Vermögenswirksame Leistungen fund for employees?
Okay, that's for your dependent employees. And as far as I remember, if the employees would like to have this, then you need to support this. But you do not need to have to pay extra money for that. So it's an option for the employees, and if they ask for it, then as far as I remember, you have to do it, yes.
Brilliant. Fantastic. Thomas, thanks so much for your time today, and thank you for your input, guys that have joined. Superb audience as always. Really good session. There are a few more questions left. We'll try and address some of those on follow-up. A quick reminder, I'm hosting another session next week on the Netherlands. So if you've got any interest in that territory, then please feel free to jump on the session again on Thursday. Thomas, it's been an absolute pleasure. Hopefully we get time to put in the diary maybe another one of these later on in the year. But thank you very much for your time. Thank you everyone to the audience, and have a great afternoon, everyone.
Thank you. See you. Bye-bye.